Welcome everybody to our monthly webinar. We had a break for the summer, but we're back and we're pleased to be running these pretty much every month through the autumn into next year. And today, hopefully you're aware, we're talking about TUPE. So it's great to be presenting with James and Laura, and I'll introduce the team in just a moment. But before then, just a couple of bits about Acton. So we're based out of Nottingham. A lot of you will know us already. In fact, we're working together. But if you don't, we're based out of one office in Nottingham. We cover the UK, and we work with a number of household names, some of which are on the slide there, as well as a number of amazing SME businesses, both locally and beyond. And obviously, we are the employment team. We also cover corporate, commercial, dispute resolution, and real estate on the commercial side, and then some other private client services too. So we're sort of a full service firm, but small enough to work on building relationships with clients in a way that we're really sort of enthusiastic about and proud of. The team, you'll hear from Laura and James as we go through. I should say Laura is not feeling very well, and in fact has a croaky voice, so she's bravely battling on through. If the voice goes, it may be that James and I step into the breach, but we appreciate Laura joining this morning and giving it a go. So we'll see how that goes. Hopefully the voice will hold. And then in terms of what we're going to be looking at today, we're going to give you a quick overview of what we're going to cover. So we're going to look at when does TUPE apply, so the circumstances that it applies in. We're going to look at what's called the automatic transfer principle. We're going to look at the enhanced protections that TUPE provides, and we're going to look at how that plays out in practice. We're also going to look at some of the risks. So obviously, often we spend our time advising on the worst case scenario. What's the risk? What could happen in these circumstances? And part of the reason for this seminar is learning how to navigate TUPE well, but also being aware of the risks involved. I should also say we have a chat function available as we go, because there's obviously three of us presenting. We're really happy to take questions along the way through the chat function. There is a Q&A section. I wouldn't put the questions in there. I know that's slightly counterintuitive, but actually we found that the chat function works really well. And if you have any queries as you go, feel free to type them in there. We're really keen for it to be an interactive session, so very happy to pick those up as we go. As I say, we will also have a more formal Q&A session towards the end. So if you do have anything there, either we can pick those up through the chat, or if you're feeling brave, we can unmute and actually have a discussion, which again is really useful too. So hopefully that gives you an idea of where we're going. We're hoping to be between an hour and an hour and a half as advertised. So we'll get going, and I think I'm handing over to Laura straight away.
Yeah, good morning, everybody. As Nick said, apologies for the fact that my voice is very croaky and may disappear at some point. So the first slide is obviously when does TUPE apply? So we've got the TUPE applies when it's a relevant transfer, and that's loosely broken down to cover two different types of events. So where there's a business transfer, where a business or part of a business moves from one employer to another, and that can include things like mergers, when two companies close and combine to form a new one. And then a service provision change, where a client engages someone to do work on their behalf and re-engages that type of work. So one of the most common examples, and I think all of us will probably use that at some point during the seminar, is a cleaning company that you get somebody in to do your cleaning, and then change who does that for you. So a business transfer involves three elements. The first one being an economic entity. There is a legal definition of what that means, which I'll talk you through. It means an organised grouping of people, assets, facilitating the exercise of an economic activity which pursues a specific objective. So it's a very fancy way of saying that you've got a grouping of people or resources that do a very specific thing. You'll see then that includes a transfer of that economic entity. So that needs to either be done by somebody else or moved to a new employer. and that entity needs to retain its identity following the transfer. And I'll talk you through what retaining identity means and how you look at that. So identifying a business transfer, there's something called the going concern test. This is the test used to identify whether there has been a transfer of an economic entity, e.g. whether that thing still exists after the transfer. The bullet points on the slide in front of you set out what is considered. Obviously, this is something that we could go through with you at the point that we needed to if we were looking at this for you guys. But this is just a brief overview of the type of things that are looked at. So I won't read them all out to you, largely because my voice might go and you can all see what's on there. But the general gist of that is the weight and importance of each of these different factors will vary on a case-by-case basis. So obviously that's something that we could look at the point that we needed to, if there was a TUPE transfer. The second type of relevant transfer is a service provision change. There's three separate types of that. So there's outsourcing, where a service that's carried out in-house, e.g. somebody just mucks in and cleans the office, is then awarded to a contractor outside. So you appoint a cleaning company to come in and do that for you. There's second generation outsourcing, where you've got a contract that provides these services and it's given to a new contractor. So you currently engage cleaning company A to come and clean your offices, and that's moving to cleaning company B. Or there's insourcing, where a contract ends and the work is transferred back into house by the former client or customer of that. So it was formerly carried out by cleaning company A, and you decided to bring it back in and get somebody to do it internally. The service provision change conditions that are required. So we've got the organised grouping of employees, which the legal definition of is a team of employees who are essentially dedicated to carrying out the activities that are set to transfer. So there'll be no organised grouping of employees where, for example, a cleaning company services a particular client using different ad hoc cleaners. So whoever turns up on the day gets sent to go and do that cleaning job. But there would be if the same team or group of employees routinely clean and service that client. After the change of the provision, the activities need to be fundamentally the same. So obviously in that example, it would be continuing to clean the same building for the same people. There is case law that says that this should be looked at on a common sense level, and that a pedantic and excessively detailed definition of the activities would defeat the purpose of the rules of the service provision change. So, for example, you can't say, well, we previously asked them to start on the top floor and work their way downwards. We now tell them to start here and work their way up. That's not sufficient to change it. And neither is making minor changes to what they actually do. And then the same client, obviously the person that is receiving the services, the cleaning, that has to be the same person. There won't be a service provision change where the contract is wholly or mainly for the supply of goods. So, for example, if you run a restaurant and you're looking at a meat supplier and you're changing your meat supplier because that's a good to you, there won't be a service provision change. And where you intend the activities to be carried out in connection with a single event or a short-term duration. So if, for example, you contract out security and you have a doorman on your pub and you decide that for one night only you've managed to get a massive band sign up and you need extra security, so you draft a whole lot more in, that isn't a service provision change. And now I'm handing over to Nick, I think.
Thanks, Laura. Well done with the voice. So the automatic transfer principle. Some of you hopefully will be familiar with the basics, at least, of how this works. And essentially, TUPE is described as working by operation of law. So it just applies when it applies. And part of the difficulty with TUPE is sometimes people don't spot that it applies, that it's relevant to the situation. Often actually in the service provision change arena. But also essentially you can't get around it very easily, because the whole idea of it is that it's protecting employment, it's protecting employees. That's the purpose behind it. And what it then therefore seeks to do is preserve continuity of employment for employees, but also transfers essentially their contracts of employment from the old employer or the transferor, as it's sometimes described, to the new employee or the transferee. And the way that's often described is that the new employer steps into the old employer's shoes. So it takes on the contracts of employment, the continuity of service, and also sort of all acts and omissions, as it's described, of the old employer. So the things that they have done to the employees before the transfer is probably a slightly non-technical way of describing it. But of course, that can involve a number of risks that transfer as part of the TUPE transfer. The other thing that often comes up and is often a dispute when we're looking at these areas is who transfers, so which employees transfer. And that's not a matter of just deciding who transfers or not, as the case may be. Either yourself, if you're involved in the process, or agreeing it with the other party. If TUPE applies, as we said, it applies, and if people are assigned to what's transferring, and we'll look at what that means in a minute, then in theory they just transfer. There's not actually much we can do about it. So one way that people won't transfer, and that's mentioned on the slides, is if employees object to the transfer. And that's something that's specifically set out in the TUPE legislation, and it's not really just oh, I'm not very happy about the fact that this transfer is taking place and I'm going to have a new employer. It's more of a formal objection that's necessary in order that this applies. Although there have been cases where there's been some debate as to whether an actual objection has taken place. And if the employees notify either party of their that they want to object, then they don't transfer, and their employment is treated as terminated again by operation of law. And it's quite an interesting one. I kind of think of it as them almost falling into the abyss, because it's not a dismissal, and they're not entitled to any statutory or contractual compensation as a result of that. So actually their rights are pretty limited if they do. And you might think as a result, it's not a particularly attractive thing for an employee to do for that reason. I think it's been included in order to allow employees to choose their employer. I think that's the sort of, again, purpose behind it. So if they don't want to transfer, they don't want to transfer, and it's one way that they can avoid that. We also come across situations where employers are thinking, do I have to notify the employees of their ability to object? And as far as I'm aware, there isn't any sort of obligation on employers to do that, but sometimes they will, and they'll also set out, the consequences of that. Again, generally speaking, the cases on this suggest that that objection should be communicated before the transfer, which obviously makes sense to avoid them transferring. There have been a few examples where it may have been an objection after the transfer, but generally that's where the employers involved haven't been particularly transparent as to when the transfer is actually happening. And it may have even happened without the employees knowing, and that's obviously a slightly different situation. So who transfers? So we talked about some of those rights, obligations, the acts and omissions that transfer. Surprise, surprise, it's employees. That's the whole idea of this. It's designed to protect their employment. It's generally not self-employed consultants, and the employees must be employed immediately before the transfer. So again, the courts have generally taken a pretty strict and literal interpretation of what that means, and that effectively those people must be employed at the moment of the transfer. So that I think can throw up some interesting situations. So for example, particularly on service provision change TUPE situations, it's not uncommon for employers to try and dump expensive employees on the transferring group, essentially, in an attempt to get rid of them. Or if they, for example, had expensive enhanced sick provisions or redundancy provisions, which again can be relevant in the TUPE situation, it may well be that they are deliberately assigned to the grouping that's transferring in an attempt to essentially dump them on the new provider. So we see that. We also get disputes as to whether people are assigned or not, and that I think probably threw up one of the most interesting TUPE cases that I dealt with a little while ago for a construction client, where there was a dispute between the parties as to what employees were assigned and who wasn't. And that really went down to the wire. So it went down to the day of the transfer and beyond, and there were still some disputes about that. And obviously, as I said, TUPE operates by law, and therefore people will have transferred. But in this situation, the dispute continued, and because these were employees who worked on a building site, essentially, the new contractor sent Big Dave, as I think he was called, in his van to pick up the people that they said were now their employees. And he turned up at the collection point, got out of the van and said, "You, not you, you, not you, you, not you," in the van. And of course, the other guys were just left there on the basis that that particular business was saying, well, we didn't inherit these employees. They didn't transfer. They weren't assigned. And of course, I said to the client, well, how did that go? You know, you can imagine there being uproar and perhaps a kerfuffle of some kind at the site. And they said, oh, no, it wasn't a problem. Big Dave is massive. So that was TUPE at its finest, I think. But again, you know, a dispute that went down right to the wire. And that I think you know, speaks into that situation of how do we decide who's assigned and therefore transferring. And part of the difficulty there is that we don't have a definition of what assigned means. And essentially what that results in is us looking at this factual question, taking into account a number of different things, a number of different factors. But essentially, the individuals need to be carrying out the duties for the part of the business that is transferring. That's one of the key elements to this. The difficulty is sometimes a bit that's transferring, people can have worked for that, but also for other bits that perhaps are remaining and not transferring. And the inclination, I think, is to then look at, okay, well, what percentage of time is spent working on the bit that's transferring? And unfortunately, the difficulty again is that there's no specific percentage that you can say, okay, well, yes, if they spend 70% of their time working on the bit that's transferring, then we know that they're assigned and they'll transfer. That just doesn't exist. And I think often, because it's one of the easiest ways of looking at it, that's what people will jump to and assume that that's, you know, what we should be assessing. But as I said, as part of the intro to this section, there are many other factors that you know, need to be considered, and that's not necessarily just a you know, cast iron. Okay, well, we can be sure because there's a high percentage, although of course it is persuasive in that regard. The other thing that sometimes happens is that people will be temporarily assigned to the grouping that's transferring. And again, as part of the preparation, I spotted a case where it was I think a student nurse who had been assigned to a particular hospital and that was then transferring, but they were only assigned for the purposes of a short period of training, and therefore it was found that they didn't transfer because they weren't actually permanently assigned there. You also get other issues around things like employees who have been suspended from work as a result of misconduct, or employees who are on long-term sick. And again, there are cases both ways on some of those situations. And you know, you do have to look at the actual fact pattern pretty carefully to assess whether those people will be assigned and therefore transfer or not. In terms of what transfers, we've kind of touched on this to a certain extent. It's the continuity of employment, it's the employment contracts, but it's also those rights, duties, and liabilities and obligations in connection with the employment contract. And obviously, that's slightly wider than just the contract. And therefore, again, it's important to look carefully at what that might actually mean. In the context of a transaction like this, what that tends to mean is that you need to have some good due diligence if you are inheriting these people as to what you're actually inheriting. What terms and conditions are they on? What benefits might they have? Because this can include things like holiday pay, medical cover, company cars, bonuses, commissions, enhanced maternity or redundancy schemes. And obviously some of those things can be pretty expensive if these employees land with you and you're not aware of what those benefits are. But essentially it's including contractual and statutory benefits. But as I said, it can be slightly broader. It can include things like salary sacrifice arrangements if they are a variation of the contract, which they nearly always will be. So it's worth ensuring as part of that process that you have as much information about what you're inheriting as possible. And we'll come on to how TUPE sort of provides for that information being given later in the session. The other thing to mention is pensions. We're not pensions experts, and I'm certainly not planning to go into masses of detail on this particular bit, even in respect of TUPE, but it's worth noting that certain benefits, in particular old age, invalidity and survivors benefits under an occupational pension scheme wouldn't transfer because they're expressly excluded by TUPE. But things like contractual rights to pay a percentage of salary into the employee's pension scheme would transfer because, again, as I was talking about before, it relates to the contract, it's set out in the contract, and therefore is the sort of thing that you could well inherit. The other relevant thing, of course, is claims. So those liabilities that it's referred to in that sort of second bullet point are also the sort of thing that you would be wary of if you are inheriting employees as a result of a TUPE transfer. And that could include things like constructive dismissal, discrimination, equal pay, that kind of thing can transfer to the transferee. And again, good due diligence as to what might have happened prior to the transfer is helpful. And if it's a business transfer in particular, you often see indemnities where the transferor or the old employer may well promise to cover certain liabilities as part of that process and as part of the commercial negotiation that's involved with that. So that's definitely worth keeping in mind in those situations. And I'm going to hand over to James.
Thanks, Nick. I nearly forgot to unmute myself. Fatal error. And hopefully you can now see the slide on enhanced protection, which is the bit I'm going to talk about. So where there is a relevant transfer and the automatic transfer principle has applied, or where the conditions that Laura mentioned at the start are enforced and there's a relevant transfer, the employees subject to the transfer have this so-called enhanced protection against dismissal. And you might well have heard of this before. Dismissal will be automatically unfair when the sole or principal reason of the dismissal is the transfer, and there was no ETO reason for it being the dismissal. I'll come on the next slide to what an ETO reason is. ETO is an acronym, as you can probably tell from the capitals. Now, when looking at these potentially automatically unfair dismissals, that covers both employees of the transferor, so the employer losing employees under TUPE, and the transferee, the employer gaining employees under TUPE. And I suppose a classic example might be where the transferee does not need additional employees because it perhaps already has enough staff to cover the work that it's acquiring and decides to make redundancies. And that would work either way, whether they were made before or after the transfer. They would be related to the transfer, that would be the principal reason. And so whether or not that was automatically unfair, we'll come on to, but it would certainly be caught by this potentially enhanced protection. A bit that sometimes people miss is the second bullet point, which is that for unfair dismissals under TUPE, or where you rely on the principal reason being the transfer, the employees in question still need the 2-year qualifying service that you would need for so-called ordinary unfair dismissal claims. Now, the reason people sometimes get that muddled up is because there's a number of so-called automatically unfair dismissals where you don't need 2-year service, such as whistleblowing, where the reason or principal reason is someone's made a protected disclosure, or where the reason for the dismissal is the employee's asserted a statutory right or certain pregnancy-related reasons. TUPE does not fall as an exception to the 2-year rule. So what is an ETO reason? The actual language is perhaps not hugely user-friendly. An economic, technical, or organizational reason entailing changes in the workforce. So you're probably thinking, what does that mean? Well, some examples might be a change in location that's specifically defined within the regulations as being a potentially ETO reason, so you don't need to argue that it is. It is stated in the statute that it is. A change in the number of employees could potentially be an ETO reason. A change in the functions performed by employees. So a number of employees likely to be a redundancy situation that I highlighted. So that is potentially an ETO reason, unsurprisingly perhaps. But just establishing an ETO reason if you make dismissals, whether you're the transferee or the transferor, isn't enough to mean the dismissal isn't unfair. It might not be, it won't be automatically unfair under TUPE if you have an ETO reason, but you still need to meet the normal unfair dismissal test. So just as a quick reminder, although this isn't related to TUPE, employer needs to still establish a fair reason, potentially redundancy, although it could be other reasons, probably most likely a business or organisation that might fall within some other substantial reason. And crucially, the employer needs to satisfy the test that dismissal for the potentially fair reason was fair in all the circumstances. So the classic TUPE scenario is employer A loses or is partially acquired by employer B. Employer B then has a surplus of employees, more than they need to do the work. They go through some form of redundancy exercise. And often one of the pivotal questions that the acquiring employer, the transferee, has to consider is how they pool their redundancy situation. Because it may or may not be fair to simply pool the transferred employees. And a lot of employers are reluctant to pool their own existing employees who are already working with the acquired employees. But in many situations, it simply won't be fair not to do that. There might be a situation where it is fair, perhaps where there's a change in location. If, for example, a company acquired a production and they were moving production to their plant that was in Newcastle from the one where the employees previously worked, say in Bristol, then you could reasonably pool the Bristol employees as a single pool separate from your existing employees in Newcastle, because there's a clear geographical distinction. Whereas if, by contrast, the warehouses happen to be next door to one another in Newcastle, I think you would struggle to maintain the argument that you shouldn't pool them all together, given that the location, albeit not exactly the same, was across the road. So lots of things to consider just on your normal unfair dismissal principles if you do have a redundancy situation that arises from a TUPE transfer. There's also some sort of special rules relating to dismissals relating to TUPE, so-called deemed dismissals. So TUPE deems an employee's resignation to be a dismissal where it is in response to a substantial change to the employee's working conditions to their material detriment. So that's where the employee resigns, saying the transfer did or would have changed my working conditions to my material detriment. And if they can establish that that's correct, that there would have been or was a substantial change to material detriment, that will be a dismissal. It would be an automatically unfair dismissal subject to the 2-year service requirement, because it would be by reason of the transfer. it may be that you could make out an ETO reason, but it's probably unlikely. And the concept is quite similar to a constructive dismissal, where an employee resigns in respect of a breach of contract by their employer that you're probably all familiar with, except it's a lower bar, because they only need to establish a substantial change to their working conditions. And it could be just a quirk of circumstance. So to go back to my previous slightly odd example where I had my manufacturing plants in Newcastle and in Bristol, if you, instead of having a redundancy situation, actually were needing more staff to do the additional work that you maybe acquired from business A, and you said to all the employees in Bristol, oh, it's fine, your job still exists, but we're changing your place of work to Newcastle, I don't think they'd have much difficulty in suggesting that moving to Newcastle would be a substantial change to their working conditions. And if for whatever reason they didn't want to move all the way from Bristol to Newcastle, that was their material detriment. So these claims can arise and need to be planned for in the context of a relevant transfer in circumstances such as the one I've just made up. The next enhanced protection is a bit different and is one that you've probably grappled with in practice. Limits on changing terms of employment. So any variation to a transferring employee's terms will be void, and by void I mean not legally binding, if the sole or principal reason for the variation is the transfer, or a reason connected to the transfer which is not an ETO reason. Now, the definition of ETO reason in the context of changing terms of employment is exactly the same as the definition in the context of a dismissal. So I won't repeat all that, but just to know it equally applies. But the most common scenario where this causes a nuisance, shall we say, for employers is where employer A has employees on certain terms, and Nick alluded to this earlier, they might be enhanced redundancy terms, for example, or enhanced sick pay terms, and employer B doesn't, and employer B acquires employer A's employees. Employer B then has a sort of two-tier workforce where some have different terms for sick pay and some have different terms for redundancy, and that is potentially administratively inconvenience, and on a more sort of basic level, certain employees might be grumpy. Why does that person get better terms than me? So the temptation is always for the employer to say, well, let's make it fair. Let's harmonize everyone's terms to be the same for consistency. But attempts to do that are likely to be void, because the reason you're doing that, at least in the scenario I've highlighted, is simply because the discrepancy has arisen from the TUPE transfer. So the sole or principal reason for the variation, the harmonization, is the transfer. And if you're just doing it for administrative convenience or fairness, that's not going to cut the mustard as an ETO reason. So those changes are likely to be void. And where you can get into a bit of a tangle is employees can, in this context in TUPE, have their cake and eat it. So if employee B was offered, say, for example, an extra £1,000 a year on their basic salary to bring them into line with employee A, who's always been at the second employer, but in return they agreed to reduce their sick pay entitlement, say from 2 weeks pay to 1 week pay, they could seek to enforce both terms. So they could say that they've validly agreed to increase their salary, but the agreement they made to reduce their sick pay was void and of no legal effect. So you need to be very careful when seeking to agree variations that you don't essentially give employees additional rights in return for them giving away rights, when in fact they haven't given them away, they're void. And in the time that they want to enforce them, they potentially could have their cake and eat it. So the question you're then going to logically ask me is, when can an employer change terms after a transfer? Well, it's a few situations. First is where the changes are permitted by the employee's contract. So this goes back to the automatic transfer principle. And as Nick said, effectively the new employer is stepping into the old employer's shoes. So if the old employer had a contractual clause saying your place of work is X, but we can reasonably move you within 2 miles, then the new employer has the same benefit of that mobility clause as the old employer did. So changes permitted by the employee's contract could be enforced and wouldn't be void. But as you'll probably all appreciate, the ability to make changes unilaterally by way of variation clause is quite limited. but where you can, such as a mobility clause, the new employer could. The next would be where the changes do not relate to the transfer at all. So a particular example that might be if you're in a manufacturing context, the sudden loss of an order, you might have to say reduce hours for employees because production is massively decreased. That would be a potential example, or a recent example that you might all gasp at with fear, COVID. That wouldn't have related to the transfer, and you might have agreed with your employees to reduce their pay and hours as part of, I think it was the furlough scheme, but something similar could happen in the future, and that wouldn't relate to the transfer, it would relate to something else. And finally, where there is an ETO reason. So if you wanted to change pay and conditions as part of a wider restructure, then you've got a better chance of arguing that that wasn't just related purely to the transfer, it fell within the ETO reason, because you can only employ so many people, or there's only so much money, and people's salaries have to come down in that respect. So those are three scenarios where you might be able to change conditions, but as you'll see, just the simple harmonization isn't one of them. One of the questions I get asked about harmonization all the time is, how long do we have to wait? At what point does it no longer become, is harmonization no longer about the transfer? And the answer to that is there isn't an amount of time you have to wait. The question is still, was the reason that you wanted to harmonize the transfer? And if you can't come up with another reason, it probably is. So just waiting 2-3 years isn't necessarily mean you've got a safe haven. Clearly, the further away you are from it, the less chance it is to be to do with that. But it might not be if there isn't any other reason. So that's the enhanced protections. The next bit is more the practical aspect of TUPE that you may or may not have become embroiled in, which is the duty to inform and consult. And hopefully I will be able to bust a few myths and correct a few common misconceptions on this. So what must employers do? They must inform and, if appropriate, and we'll come on to what I mean by that, consult with appropriate representatives of affected employees. Now, I've underlined appropriate representatives. I possibly could have underlined affected employees too. The 2 bullet points cover the 2 things. So what's an affected employee? That's any employees who may be affected by the transfer or by measures taken in connection with it. So this includes, probably obviously, the employees who will be in scope to transfer from one employer to the other. But they also include employees of both the transferor and the transferee who aren't in scope but might be affected because, for example, their jobs might change because in employer A, other people might be leaving, and so part of the business that they previously worked in, say a small percentage of their time, but because they weren't assigned to the organised grouping that's transferring, they are staying, but they might still be impacted by the transfer, so they're still within scope of the duty to inform and consult. So who do you have to consult with? The big underlined bit, appropriate representatives. Now, I think a lot of people, and I have some sympathy with them, agree that this is potentially in a lot of cases impractical, but appropriate representatives are representatives of a recognised trade union, if there is one, and nowadays that's becoming rarer and rarer in sort of SME employers and more common in bigger businesses or the public sector. Or if there isn't a recognised trade union, elected employee representatives. Now, the elected employee representatives can be specifically elected for the purposes of a transfer, or existing representatives where their appointment and the remit of their appointment gives them suitable authority to undertake the role. So an example given in some TUPE guidance, which I think the government actually is taking off the internet now, but I don't see why it's wrong, would be a works council that's regularly consulted about key financial matters. So it would seem logical that consulting with them about a TUPE transfer would be similarly within their remit. Whereas if they were just a committee to discuss what's on the canteen menu, then they're unlikely to be elected. As appropriate elected employee representatives for the purposes of TUPE. So can't employers just inform and consult directly with the affected employees? Well, the general answer to that is no, except for in a few scenarios. The first is where, after the employer has invited any affected employees to elect representatives, they fail to do so within a reasonable time. Now, I think people get overly excited by that and think, well, they haven't elected any, so we'll just consult with them directly. I think on most employers, unless you're extremely small or unsophisticated, that an employment tribunal would expect you to at the very least invite employees to elect representatives, give them a bit of time and give them a bit of assistance how they might do so, whether that's with ballot papers or some other mechanism of doing it. And the other scenario is where the employer has fewer than 10 employees, so nine or less. That was a change that was made to TUPE in, I think, 2014, the so-called micro business exception. And whilst a good idea to assist the very small employer with the sort of red tape of TUPE, what it has led to is a bit of confusion where people have got very excited and decided that where there are fewer than 10 employees transferring, they are a micro business. Well, that's not correct. The amount of employees transferring is totally irrelevant. It's how many employees in total the employer has. So if the employer has 10 people or more employed, then you have to consult with not affected employees. You have to consult appropriate representatives, not the employees direct, save for the one exception where they are invited to elect representatives and they fail to do so within a reasonable time. So that's who you need to consult with and in relation to which employees. What is the actual duty to inform or consult? Well, I'm going to take it in two stages. Perhaps logically, we'll look at informing first and second. So what is the obligation to inform? Well, you must provide information so-called long enough before the transfer to enable the employer to consult the appropriate representatives. There's no magic answer to what long enough is, and there can be a bit of commercial tension where employers are often concerned that they're in discussions about a potential transfer and it might fall through, or there's other commercial sensitivities and they don't want to unsettle employees by telling them things too soon. The employment law aspect to that isn't hugely sympathetic. The employment tribunals would expect you to consult in good time. I always say that you should use as much time as you can, and you have to balance the commercial sensitivities. To do a sort of thorough job, you would ideally want at least a couple of weeks. But if you've known for many, many months and you only start consultation 2 weeks before, that's certainly something the employment tribunal could pick at. What information do you have to provide the appropriate representatives? You need to provide them the fact of the transfer, details of the legal, economic and social implication of the transfer. What does that mean? Well, case laws describe that to be sufficient information to assess the impact of the transfer. So telling the appropriate representative enough so you can understand what's going to happen and what the impact will be, whether that's on social implications like place of work, time of work, duties, or economic. Is it going to be to do with pay and wages, or legal is more the points that Nick was saying about who becomes their employer, is their continuity of employment affected, things like that. So that needs to be provided. What other information? Measures envisaged by both the transferee and transferor. On the next slide, I go into more details what measures means, but it's quite a broad definition of any sort of step, action or arrangement. And you must also provide certain information about the use by the employer of agency workers. I only flag this one because it's often missed off because many employers just simply don't engage agency workers. And it's one of those weird employment law scenarios where you just have to confirm the negative, which is that the employer doesn't engage agency workers, or if it does, how does it? So that's the duty to inform. I now come on the obligation to consult. And this is often a bit misunderstood. So the obligation to consult is only triggered if the employer, that's the employer of the employees, the affected employees, envisages that in connection with the transfer, it will be taking measures in relation to any affected employees. So as I've said on the slide there, what is a measure? It's broadly defined to be any positive act or omission by an employer. Now, it could be little things like changes to job roles, duties. It could be bigger things like hours of work. And then perhaps the most common significant measure is where one or other party proposes redundancies. And that's where often confusion lies, because consultation should be with you to reaching agreement, and the consultation you're doing is in relation to any affected employees. And so it's quite rare that the transferor, that's the employer who's doing the consultation with its own employees who are due to transfer, and potentially some others, has particularly significant measures. There might be a few things that perhaps are changing in the lead up to the transfer just to prepare for it, but often it can be business as usual up until the point that the employees transfer across. And it's often the transferee that's proposing to make redundancies. For example, the scenario I talked about earlier, where the acquiring employer is going to have more employees that they need. And what the employer of the employees who are due to transfer does not need to do is consult with its own employees about the proposed redundancies that the transferee might make after the transfer. They have to inform them of that potential measure, as I mentioned on the previous slide, and the transferee's got a duty to inform the transferor of its proposed measures so that they can comply with their duty to inform. But the employer who's losing the employees doesn't have to consult about the proposed redundancies, because that would simply be impossible, especially where consultation with the view to reaching agreement, because you couldn't consult with someone about something you don't propose to do. If they had any questions, you couldn't answer them. You couldn't really explain why or the business rationale, because it's not your business rationale. You just need to consult with them of things that you plan to do to your own employees. Any consultation about redundancies that are to be affected after the transfer by the transferee should be conducted by the transferee after the transfer, but that wouldn't fall within the scope of the duty to inform and consult. That would just be consultation on proposed redundancies. That said, sorry, I should have moved the slide because I've just highlighted the first bullet point, the common misconception. The point I was about to make is it's very, very common that the inquiring employer may wish to meet the transferring employees pre-transfer. Now, that's not required by TUPE, but I can certainly see, and I've seen in practice, that can be very beneficial in terms of employee relations and ensuring that the employees are understanding what's going to happen and aren't sort of thrown cold to the new employer on the day after the transfer. So it's worth understanding that that's not actually part of the TUPE process, but can be useful in terms of employee relations. And to state the incredibly obvious, if you keep employees fully informed of all matters, even if it's not technically within the duty to inform and consult, and keep employees happy, then they're much less likely to bring claims. The other common misconception, although I've seen this less and less in recent years, I don't know whether that's because employers are getting more familiar with TUPE, it being quite long into its life now, is that there's no obligation to inform and consult after the transfer. If you haven't done it before the transfer, you're too late. You're not going to be able to say that you did it afterwards. And there's a certain logic to that, because as soon as it's happened, there's any informing and consulting is futile. People will have transferred, things will have changed. So you need to do it beforehand, not afterwards. So that's informing consulting. I'm now going to pass back to Nick to talk about employee liability information.
I'm hoping that he's not, because it's Laura's bit, but thanks, James. Good try. Thanks, Laura.
I was hoping I got away with that then, guys. So yeah, the employee liability information, as you'll see, it's prescribed information about the employees. So as Nick said, I think in the chat earlier, if you do have trouble sleeping, you are welcome to go and look at any of these regulations and have a good read through. The full list is on there for you, but it's generally terms about your employees, so their name, age, contracts, terms of employment, those sort of things. You'll also be looking at any disciplinary or grievance records, and that's usually for about a period of 2 years. And the other things that are relevant are things like agreements between the current/outgoing employer and their employees with the trade union. Employment tribunal claims in the last couple of years, or anything that is expected, would also need to be provided. So that's just worth having in mind. you'll see that you'll need to provide the ELI, the employee liability information, not less than 28 days before the relevant transfer. Now, we'd always recommend getting it done pretty much as soon as you can and starting to collate that at the point that you know that this is likely to happen. And then the other thing that often gets missed is that you need to try and keep it updated. So making sure that if anything changes to any of the information you provided, you're updating that as you go through the process. Employment tribunals, the common claims arising from a TUPE scenario is unfair dismissal. The statutory cap on unfair dismissal compensatory award applies here. So you might remember that earlier this year it went over £100,000 for the first time, had a fairly substantial increase. So it's now the lower of a year's pay or £105,707. There's also the claim for failure to inform and consult, which obviously James has just talked us through. The compensation for that is capped at 13 weeks gross pay per employee. And the thing to note here is that the statutory limit on a week's pay doesn't apply, so it's the actual gross pay of each employee. And then the failure to provide the ELI, which we've just spoken about on the other slide. The tribunal can award a minimum of £500 per each employee in respect of who information wasn't provided. So that's worth having in the back of your mind too. Right, so we'll open the floor to questions.
Thanks, Laura. So obviously we've been through a fair amount there, and there is a reasonable amount to TUPE. For some who are familiar with it and doing regular TUPE transfers, you may think, okay, well, that was all helpful as a refresher, but basic. And if there are more complex situations that you'd like to talk about, that'd be great. Other people may be thinking, oh my goodness, I didn't realize there was so much to this, and have questions that you'd like answered to clarify. So do either unmute and fire away or pop something in the chat if that would be helpful. I'll leave it just a minute.
Or has TUPE ground everyone down into a state of comatose quiet?
That's also possible. It's also possible. Well, while people are having a think, I'll just give you a. Oh, sorry, Nicola has said I can't unmute. Let's see if we can.
I wonder if that's an issue with the thing. But to talk whilst we try and look into the technical. So, if the undertaking is situated in the UK, so the employees are in the UK prior to the transfer, then if the work is going abroad, then yeah, TUPE would still apply. It's to do with where the employees are based immediately prior to the transfer. Clearly, then you trigger some of the things we talked about in terms of ETO reasons and redundancy situations, because I'm guessing not that many employees are going to say, oh yes, fine, I'm quite happy to keep my same terms and conditions, but just move to another country, depending where the work's going. Yeah.
So Nicola, I've tried to change a setting, which might mean that you can unmute, but hopefully James has covered that. If not, either unmute or pop another question in.
Oh, EC has asked a question. Oh, sorry, I can read your name now. Apologies for that slightly in Ekaterina. It's an interesting one, ELI information, because yeah, I've experienced that in practice where employers are doing it too late and certainly not within the 28 days you're supposed to do it now. But I've never once had a claim, because it's one of the only types of claims, I'm not sure I can think of any others, where one employer sues another. So the employer is the claimant. I don't even know how you'd fill in the form, because I've never done that before. But it could theoretically happen, and it obviously has happened, because there's some case law on the £500 that Laura mentioned of how much people have been awarded. But oddly, it just doesn't happen. I suppose it's often because, certainly in a business sale or asset transaction, there'll be contractual obligations that probably be easier to enforce against each other than bothering to go through the employment tribunal. Or there might be other contractual provisions where the parties have agreed that they've complied with their duty to provide the employment liability information, even when they haven't in a separate commercial contract. So yeah, could be claims, but oddly, you just don't see them. I've not in over 10 years.
Yeah, I suspect it might also be because if the the new employer gets the information eventually, they may just think, okay, well, we'll deal with it now, and we're not going to bother with a claim. You know, commercially, it doesn't make sense. That might be part of it too. Right, the questions are
Piling in.
piling in.
So Claire's question is a tricky one because it's not really about TUPE at all. But what we can say is you're inheriting the acts and omissions. So if your concern, Claire, is that they haven't done the relevant checks, whether that's immigration checks, DBS checks, then you're potentially on the hook, yes, for not having done them. So subject to data protection considerations, I don't see why not.
Yeah. So James, Nicola's got a follow-up question on the
questions.
Transferring abroad. So if work transferring abroad, then change of location, but would it be the company abroad that would have the ETO reason?
Yeah, essentially is the answer to that. So yeah, you have to be careful on whose ETO reason is. So if you're the employer that has the employees who are in scope to transfer because you've outsourced or because you've sold off or whatever, you're very unlikely to have an ETO reason or a redundancy dismissal that can be fair, because you're going to need all your employees to carry on whatever it is they're doing up to the point of the transfer. It's the transferee who's acquiring the business who doesn't need your employees. So they're the ones who are going to have the ETO reason. So usually, even though commercially this is often unattractive, the person who can fairly dismiss after the transfer is the acquiring employer. But especially in the context of your scenario where the acquiring employer might be abroad, and they're, I'm making an assumption here, not so familiar with UK employment law and employment rights, you're in a bit of a pickle. So you might have to come to some kind of conjoined approach or some other pragmatic solution there. But yeah, they've got the ETO reason, you don't.
Yeah, and Kelly's raised a question about harmonising on more favourable terms post the transfer. She says, if you have the majority of employees wanting to sign up to the new T's and C's, can you enforce for everyone following appropriate consultation? Also, given the terms are significantly more favourable, does it reduce the risk if an employee did choose to resign?
It's kind of two levels to that question,
a number of
isn't
different things to that.
Yeah, there's two levels to that question. So as I was saying in the section I talked about, I might as well answer that one because it was on my bit, on harmonisation, where you say more favourable, employees can agree to improve their terms and conditions, but the tribunals don't look at it in the round. They look at it term by term. So even if there was just one aspect of the new terms that were less favourable, the employee could agree the new terms and still rely on the old term that was more favourable. They can cherry pick. The second part is, can you enforce for everyone following appropriate consultation? Now, that's to a certain extent partly a question about changing terms and conditions. So if they don't agree to the change, if you unilaterally impose a change of terms and conditions on an employee, then that's likely to be a fundamental breach of their employment contract that they could choose to accept and resign and claim unfair dismissal, or a constructive dismissal and unfair dismissal if they got requisite service. If you're consulting with a view to terminating their employment and then offering them re-engagement on the new terms, if the reason you were terminated was to harmonise because of the transfer, then that would be automatically unfair unless you could establish an ETO reason. If that wasn't the reason, then you just have to show that dismissal because of their refusal to agree the new terms was fair, applying the case law on that, which is the topic for another seminar. I don't want to speak for half an hour about when you can change terms and conditions. So yeah, usually harmonising up is generally successful, but you just have to be careful that someone doesn't cherry pick one of the terms that was less favourable before, because they can. Even if the only thing I suppose I'd say is in practice, do all employees know that? Probably not, but you have to be aware that they might.
Yeah. And it always seems strange, doesn't it, that employees are allowed to do that, effectively pick and choose, or cherry pick, as you described it, James, the most favourable terms between their old and the new, even though they're agreeing to the new. And we've certainly seen situations where that's happened, you know, a good while after the transfer too. So yeah, it's
unless there was an ETO reason that gets you out of this whole problem.
Yeah. Abby question: if you consult based on a transfer date and then move the transfer date moves, what are the impacts, and do you have to engage in consultation again with the reps? So I guess a transaction being delayed.
My question again. So on your duty to inform, yeah, you should continue to inform. So you're supposed to inform of the date or approximate date of the transfer. If you find out that's changing, you should inform. Whether you need to consult would depend on whether the fact that the change of date is happening, whether that leads to any measures, because you only have to consult on measures. So if there's anything they need to do because it's being delayed, then yes. If there are no measures that that employer is imposing because of the change that haven't already been, because if they've already been consulted on and it's just carrying on for a bit longer, then I suppose you probably should revisit that as well, just saying, informing it's changing on until this date. So the proposal is we just carry on with whatever measures we've already agreed on in consultation until the new date. But if there were no measures, then no.
Yeah, practically you're going to let them know, aren't you? Another one from Nicola. James, this is another one for you, I think. Where some affected employees are represented by a recognised trade union and others are not, might there be two parallel consultations?
There might be. You wouldn't necessarily have to. You could just have the trade union representatives or representative and the elected employee representatives to the same meeting to save yourself time. And I don't think you mean this from the question, but just in case anyone else thinks this, is if there's a recognised trade union and the affected employees are within the bargaining unit that's covered by the recognised trade union, the fact that individual employees might not be part of the trade union is irrelevant. It would only be where the affected employees weren't covered by a recognised trade union. So, for example, if there were manufacturing employees that were covered by the recognised union and there were senior management who weren't, then you might need to elect a representative for the senior management, but not the manufacturing.
Yeah. And then Ian's messaged, I'm not entirely sure we have enough detail, but it says if they're offered a new role after the transfer, can you get them to sign a new contract?
Yes. And I suppose that that's more likely to fall within a ETO type situation, because there's going to be a change to job role and functions of that person. So you're less likely to be stuck in the scenario I was talking about before, where they can cherry pick, because although the reason for the new role may well be the transfer, it sounds as if there might be a change in job role or function that means you fall within the ETO definition.
Yeah, makes sense. It's going to be circumstance specific, isn't it, on that basis, I think. And we might have got to the end of the questions, James. So well done. Do fire them in as I'm closing. If you have any other burning questions, we just wanted to let you know about a couple of other things before we finish and let you go. We've been running for a little while a free employment contract review where we basically look at your contract and tell you if it's legally compliant or not and where changes might be necessary. There were some changes in around 2020, off the back of the Good Work Plan, to contracts which require certain things to be included in them for new starters. And because COVID hit around then, you might remember, a lot of employers seem to have missed those. Some haven't, but some have. And therefore, if it would be worth a quick check over of that for you, and we'd be happy to. The other thing that we're doing a lot of at the minute is online and in-person training. So certainly we're seeing an increase in HR teams wanting upskilling, but also managers on things like running disciplinaries and grievances, discrimination, equality, that kind of stuff. And we do a fair amount of that. If you're on the webinar today and you're an HR professional, we have something called the East Midlands HR Network, which is a great way of getting HR professionals together to share sort of best practice and knowledge and their experience of things. We run roundtable events and some larger events which we have coming up, and we also have fairly recently, released something called the HRD Talks podcast. And again, I think Avetta is popping links to these various things in the chat if you'd like to check those out. We've got some great guests on the podcast, and we certainly have found that the feedback's been good, and people have found them helpful. And the other thing that I think we've already popped in the chat is the Knowledge Hub on the Actons website, where you can check out some of the podcast, but also recordings of all the webinars that we've done. So if you've missed any of those, it's really easy. You can jump on there and watch the previous webinars that we've run on YouTube. And yeah, there's the details of the most recent episode of the podcast, which was a fun one with 2 guests from local SMEs in the East Midlands. The other thing just to mention, we're in the process of putting the date in the diary, but next month our webinar will be a more general employment law update. So they tend to cover a whole range of topics. So there's definitely something for everybody. There's been actually a few changes in employment law recently, new rights and obligations for employers, sort of getting royal assent and various bits of legislation in the pipeline. So it is useful to keep up to date on that. And as I say, keep an eye out for details. Usually we'll be posting that kind of stuff on LinkedIn, where we're pretty active, but also if you're on our mailing list, you should get that invite too, and it would be great to see you next time. Thanks, Laura and James. Thanks everybody for joining us, and as I say, we hope to see you for the employment law update in October. Thanks everyone.